On your knees. Hands behind your head. Do it now. The command came wrapped in authority and something darker, something that had nothing to do with law enforcement and everything to do with power. The kind of power that feeds on compliance, the kind that mistakes submission for victory. Meredith Holloway lowered herself to the asphalt. The surface burned through her slacks, summer heat still radiating from pavement that had baked under Georgia sun for 14 hours. Her knees found the road. Her hands found the back of her head. Her eyes found the middle distance, that space between here and somewhere else, the place where dignity goes to wait until it can return. Interstate 285, 11:47 p.m. The shoulder of America's busiest perimeter highway, and a black woman kneeling like a suspect in a felony stop. Except there was no felony. There was barely a reason. The officer's flashlight swept across her face. She didn't blink, didn't flinch, just breathed, counted. 1, 2, 3. Behind her, the cruiser's radio crackled, dispatch confirming what she already knew, what her documents had already proven, what this officer had chosen to ignore. Unit 47, dispatch shows vehicle registration valid. Repeat, registration valid. Owner matches license presented. No warrants, no flags. The officer, his nameplate read Garrett, didn't acknowledge the transmission, didn't move to help her up, didn't apologize for the mistake that wasn't a mistake because it was never about the car. Instead, he leaned down, close enough that she could smell coffee on his breath, close enough that his next words landed like they were meant to land, personal, pointed. I don't care what dispatch says. I know what I'm looking at. 31 seconds on her knees. 32, 33. She had counted longer waits than this. In courtrooms where justice moved like cold honey, in chambers where deliberation required patience measured in hours, but never on her knees, never on burning asphalt, never with a stranger's assumption pressing down on her shoulders, heavier than any hand. The second cruiser arrived. More lights, more authority, more witnesses to what was happening and what would happen next. She kept counting. The truth would come later, the receipts, the recordings, the reckoning that this officer couldn't imagine because he couldn't imagine who she was. But that was later. Right now, there was only the road, the heat, the waiting, and somewhere in the back of her mind, a clock that had started ticking the moment his lights appeared in her mirror. That clock would run for 3 weeks, and when it stopped, Officer Wade Garrett would learn exactly what he was looking at. He just didn't know it yet. 36 hours earlier, the world operated on a different rhythm, a rhythm Meredith Holloway had spent 15 years perfecting, a rhythm built on precision, routine, and the quiet power of consistency. Her alarm sounded at 4:58 a.m., 2 minutes before the scheduled 5 o'clock, always 2 minutes early. The habit had started in law school, when oversleeping meant missing the library's best study carols. It had calcified into ritual during her years as a prosecutor, when preparation meant the difference between conviction and catastrophe. Now, 23 years into a legal career that had taken her from assistant district attorney to the federal bench, the 2-minute buffer had become something else entirely. Control. In a world determined to remind her that control was an illusion for women who looked like her, she claimed it in small ways, precise ways, ways that left no room for chaos to creep in uninvited. She silenced the alarm before it could complete its first chime. The bedroom stayed dark. Her husband, Ethan, slept on, his breathing steady, undisturbed. She moved through the pre-dawn blackness with the confidence of someone who had navigated this exact path 4,000 times. Bathroom, sink. The cold water she splashed on her face. The running clothes laid out the night before, folded on the chair by the window in the same configuration every evening. Her running shoes waited by the back door, laces pre-loosened to identical lengths, positioned so she could step into them without bending, without adjusting, without losing a single second to friction. The kitchen counter held exactly 3 items, 1 folder containing the day's priority documents, one pen, one coffee mug with its handle facing right. Everything else had been cleared, wiped, returned to cabinets and drawers where order lived and chaos was not welcome. She stepped into the morning. Georgia in June meant humidity that wrapped around you like a second skin even before sunrise. Piedmont Park stretched ahead, its paths empty except for the occasional fellow early riser, the dedicated and the desperate, the ones who understood that the hours before the world woke up belonged to those willing to claim them. Her pace settled into its groove. 8 minutes, 12 seconds per mile. The same pace she had run yesterday. The same pace she would run tomorrow. Not because she couldn't go faster, but because consistency was its own form of strength. Predictability was armor. When everything external conspired to remind you that you were other, different, suspect, you built your internal world on foundations that could not be shaken. 3.1 miles. The loop she had designed herself, mapped on her phone years ago, and memorized until the phone became unnecessary. Past the lake, through the meadow, along the tree line where cardinals gathered in spring, and mockingbirds claimed territory in summer. Her feet knew every route, every dip, every spot where rain collected and made the path treacherous. She ran it all without looking down. By 5:42 a.m., she was home, showered by 6, dressed by 6:20. The suit she chose was charcoal gray, conservative, deliberately unremarkable. Her judicial robes would cover it anyway, but what she wore underneath mattered. It was the foundation, the structure that held everything else in place. Ethan was awake when she came downstairs. Coffee made, 2 cups on the counter, his and hers. He worked from home most days now, corporate law practiced through video calls and document reviews, the pandemic having permanently rearranged how attorneys operated. He looked up from his tablet as she entered. The Henderson brief came in overnight. They're pushing for summary judgment. She poured coffee, took a sip, let the warmth settle before responding. They won't get it. The factual disputes are genuine. Baxter knows that. Baxter knows a lot of things. Doesn't stop him from trying. She almost smiled. Almost. The corners of her mouth moved a fraction of an inch, the closest she came to visible amusement most mornings. Ethan had learned to read those fractions over 19 years of marriage. He called them her micro-expressions, the emotional equivalent of classified documents, available only to those with proper clearance. She finished her coffee, rinsed the mug, placed it in the dishwasher with the handle facing the same direction as every other mug already inside. The folder on the counter went into her briefcase, the pen into the interior pocket, everything in its place. "Late night tonight," she said. It wasn't a question. It was a notification. The Garrett case file required review before tomorrow's hearing. Excessive force allegations against a 12-year veteran of the Atlanta Police Department. 3rd complaint in 4 years. Pattern emerging from the paperwork like a shape in fog, gradually clarifying, gradually becoming undeniable. Ethan nodded. "I'll leave something in the fridge." She kissed his cheek on her way to the garage. The door to the house closed behind her with a soft click. The garage light flickered on automatically, illuminating the vehicle that waited in its designated spot. A 2019 Toyota Camry, gray, 4 doors, factory wheels. No modifications, no personalizations, no bumper stickers declaring opinions or affiliations. The car equivalent of a blank page. Deliberately, consciously, strategically unremarkable. Some of her colleagues drove German sedans. Mercedes, BMW. The occasional Porsche for the judges who had made partner at major firms before ascending to the bench. They saw no contradiction in it, no risk. They drove what they could afford, what they had earned, what reflected their station. Meredith had learned a different lesson. Visibility invited assumptions. Assumptions invited confrontation. A black woman in an expensive car in certain parts of this city, at certain times of night, became a question that demanded answers. Whose car is this? Where did you get this? Do you belong here? The questions might stay unspoken, but they lived in the eyes of the officers who ran plates without probable cause. The security guards who asked for identification they wouldn't request from someone else. The neighbors who watched a little too closely when she pulled into unfamiliar driveways. The Camry was invisibility. And invisibility, for a black woman who had spent her entire career being hyper-visible, was worth more than leather seats and a prestige logo. She backed out of the garage. The route to the courthouse was 17 minutes in light traffic, 23 in heavy. At 6:38 a.m., the roads were still manageable. She drove the speed limit exactly. Turn signal activated precisely 3 seconds before each lane change. Full stops at every sign, the kind of stops that would satisfy the most pedantic driving instructor. Habits. Armor. The 1,000 small protections she had built over decades of existing in spaces that were not designed for her, that had to be claimed and defended and claimed again. The parking garage beneath the federal courthouse had 3 levels. Judges parked on the lowest level, closest to the secure elevator that bypassed the public floors. She had parked in the same spot for 15 years. Third space from the elevator. The number felt like superstition but functioned like strategy. Consistency meant never having to think about where you left your car, never having to wander through a concrete maze at the end of an exhausting day, never being vulnerable for a single unnecessary second. She pulled into the space, gathered her briefcase, stepped out of the Camry. The security guard at the elevator checkpoint was new. She had noticed him 3 weeks ago, replacing Marcus, who had manned the post for her entire tenure on the bench. The new guard was young, early 20s, still wearing his authority like a costume he was trying on for size. "Ma'am?" He held up his hand as she approached. "I need to see identification." She stopped. The briefcase hung at her side. Her judicial credentials were in her wallet, in her purse, in the briefcase. Retrievable, provable. But that wasn't the point. "I'm Judge Holloway. I've parked in this garage for 15 years. "New protocol, ma'am. Everyone gets checked. I need to see ID." She studied his face, looking for malice, looking for the particular flavor of obstruction that came wrapped in procedure and justified by rules. She didn't find it. What she found was something almost worse. Genuine ignorance. He didn't recognize her because he hadn't bothered to learn the faces he was supposed to be protecting. He was following orders without understanding context. A small failure with large implications. She opened her briefcase, retrieved her wallet, extracted the credentials that identified her as a United States District Court judge for the Northern District of Georgia. She held them up, face out, the way she had held them up dozens of times over the years for guards and officers and officials who needed proof that she belonged in spaces she had every right to occupy. The guard studied the credentials, studied her face, compared them, took his time, let her wait. "Thank you, Judge. You're clear." She returned the credentials to her wallet, the wallet to her purse, the purse to her briefcase. She did not thank him. She did not complain. She simply walked past, stepped into the elevator, pressed the button for the 7th floor, and waited for the doors to close. The doors closed. She allowed herself one exhale, one moment of release for the tension that had gathered across her shoulders during those 30 seconds of unnecessary verification. Then she straightened her spine, lifted her chin, and prepared for the day ahead. The 7th floor housed her chambers and 3 other judges' offices. The hallway was empty at this hour. She preferred it that way. The solitude of early morning, before the clerks arrived, before the phones began ringing, before the building filled with attorneys and plaintiffs and defendants, and the endless human machinery of justice seeking resolution. Her office door read, "Judge Meredith Holloway," in brass letters that had tarnished slightly over the years, developing a patina she secretly appreciated. New brass looked too eager. Tarnished brass looked like it had earned its place. She unlocked the door, stepped inside, closed it behind her. The chambers were exactly as she had left them yesterday evening. Desk clear, except for the computer monitor and the framed photograph of her daughter, Aisha, taken at her law school graduation 3 years ago. Bookshelves lined with case reporters and legal treatises she rarely opened anymore, the information living in her memory now, accessible on demand. Diplomas on the wall, undergraduate from Spelman, law degree from Harvard, certificates of appointment signed by 2 different presidents. She didn't look at the diplomas, hadn't looked at them in years. They were proof she no longer needed to provide. Background rather than foreground. Evidence filed and forgotten, and her computer hummed to life. Email populated. 47 new messages since yesterday evening, most of them administrative, a few requiring actual attention. She scanned the subjects, flagging priorities, deleting spam that had somehow penetrated the federal filters. Julian arrived at 8:15. Her clerk for the past 4 years, a Howard Law graduate who had turned down offers from white shoe firms to pursue a federal clerkship and hadn't regretted it for a single day. He knocked twice, always twice, before entering with the day's docket in hand. 23 cases this week. The Garrett hearing got moved up. Plaintiff's counsel requested expedited scheduling, and Judge Ashworth approved the calendar adjustment. She accepted the docket, flipped to the Garrett file. Read the summary she had already memorized. State of Georgia versus Wade Garrett. Excessive force allegations stemming from a traffic stop 8 months prior. The plaintiff, a 17-year-old named Jordan Williams, alleged that Officer Garrett had used disproportionate force during a routine stop, including placing his knee on the teenager's back for over 3 minutes, while the boy lay face down on pavement. The plaintiff had sustained bruised ribs and psychological trauma. The officer claimed justified response to perceived resistance. 3rd complaint in 4 years. Same officer, different plaintiffs, same pattern. The motion from City Council, Julian continued. They're arguing qualified immunity. Standard boilerplate, but Whitfield filed it herself, not an associate. Sloan Whitfield, city attorney, the kind of attorney who didn't waste her personal attention on cases she expected to lose. Her presence on the filing meant the city was taking this seriously, which meant the evidence against Garrett was strong enough to warrant their A-team. I'll review the motion this evening, Meredith said. Clear my calendar after 4. I need uninterrupted time with the file. Julian made a note. Anything else? That's all for now. He left. The door closed. She returned to the file. The plaintiff's complaint included a photograph. Jordan Williams, 17 years old, photographed in the hospital 3 hours after his encounter with Officer Garrett. Bruises visible on his face. Eyes that looked older than 17. The particular hollowness that came from encountering authority that was supposed to protect you, and discovering it could destroy you just as easily. She had seen that look before, in her courtroom, in case files. In the mirror, years ago, when she was young enough to be surprised by injustice and old enough to understand she couldn't let it show. Pattern emerging. She read the file a second time, made notes, identified the questions she would ask, the weaknesses in each side's arguments, the places where truth might be hiding beneath layers of legal language and strategic omission. The day progressed. Hearings filled the morning. Motions in the afternoon. The endless procedural choreography of federal court, each step prescribed by rules developed over centuries, each step designed to inch closer to something resembling justice. By 6 p.m., the building had begun to empty. By 8, her floor was nearly silent. By 10, she was alone with the Garrett file, having sent Julian home hours earlier, having eaten the sandwich Ethan packed that she barely tasted, having worked through the evidence with the methodical focus that had defined her career since before she had a career worth defining. If you are finding this story gripping so far, take a second to hit that subscribe button. You are not going to want to miss what happens next. 10:43 p.m. She closed the file, locked her chambers, walked to the elevator with the particular exhaustion that came from hours of concentrated attention, the mental version of physical labor, muscles she couldn't see aching from use, she couldn't measure. The parking garage was empty. Her Camry waited in its spot. 3rd space from the elevator, exactly where she'd left it 14 hours ago. She drove the same route home she always drove. Speed limit, exactly. Turn signals precisely timed. The habits of a lifetime engaged automatically, requiring no conscious thought, freeing her mind to process the Garrett file, to consider the arguments, to prepare for the hearing that would begin in 2 days. Interstate 285, the perimeter highway that circled Atlanta like a noose, depending on your perspective, or a lifeline, depending on how badly you needed to get somewhere fast. At this hour, traffic was sparse. Just the late-night travelers, the shift workers heading home, the insomniacs who drove because sleep wouldn't come. She merged onto the highway, found her lane, settled into the rhythm of interstate driving, the mindless forward motion that required just enough attention to prevent accident and not enough to prevent thought. The headlights appeared in her rearview mirror without warning. Close. Too close. The kind of close that was either reckless or intentional. She checked her speed, 63 in a 65 zone, within tolerance, legal, unremarkable. The lights stayed close, then closer. Then blue and red began to flash. Her first thought was practical. What could I have possibly done wrong? Her second thought was historical. This is how it always starts. She activated her turn signal. 3 seconds of blinking before she began to move. Merged right toward the shoulder. Found a spot wide enough to accommodate both vehicles safely. Pulled to a stop. Put the Camry in park. Then she did what she had taught herself to do decades ago, what her mother had taught her, what every black parent teaches every black child who will someday sit behind a steering wheel in America. Hands at 10 and 2. Visible. Still. Nothing in them. Nothing near them. Window down before the officer reached the door, so there would be no sudden movements. No reaching. No moments that could be misinterpreted, deliberately or otherwise. She watched the officer approach in her side mirror. Male. White. Medium build. The particular swagger that some officers developed after years on the job. The walk that said authority before the badge ever came into view. His hand rested on his holster, not gripping, just resting. A reminder of what he carried and what she didn't. He reached her window. Flashlight beam swept across her face. She didn't blink, didn't turn away. Let him look. License and registration. No greeting. No explanation for the stop. No good evening or do you know why I pulled you over? Just the demand, stripped of courtesy. She kept her voice neutral, informational. The voice she used in court when delivering instructions to juries, neither warm nor cold, neither friendly nor hostile. My license is in my purse, which is on the passenger seat. My registration is in the glove compartment. I'm going to reach for them now, slowly. She announced each movement before making it, reaching for the purse, opening it, extracting the wallet, removing the license, then reaching toward the glove compartment, opening it, retrieving the registration. She held both documents out the window. He took them. Barely glanced at them. Didn't study the license. Didn't compare the photo to her face. Didn't examine the registration that would confirm what she was about to tell him. This is my vehicle, she said. Registration is current. You'll see the name matches. I'll decide what I see. He turned away, walked back to his cruiser, took his time, let her wait. She watched him in the mirror. He wasn't running her plates, wasn't consulting his computer. He was on his radio, but his posture said conversation, not verification. The body language of someone confirming his own assumptions rather than checking his facts. She began to count. A habit from childhood. A way to measure time when time stretched into something elastic and hostile. 1, 2, 37, 38. He returned. His demeanor had shifted. Something harder in his eyes. Something decided. Step out of the vehicle. Officer, may I ask why? The registration is valid. There's been no violation. I said step out. She did not argue. Argument escalated. Escalation endangered. She opened the door. Slowly. Stepped out. Slowly. Stood with her hands visible, palms forward, the posture of surrender that was also the posture of survival. He grabbed her arm. The grip was excessive, fingers digging into flesh through her suit jacket. He spun her around. Fast. Her face met the roof of the Camry. The metal had been sitting in Georgia's sun for 14 hours before she'd parked in the courthouse garage. It was still warm, even now, even approaching midnight, heat radiating against her cheek. A second cruiser arrived. More lights. More sirens cutting through the highway noise. The door opened, and another officer emerged. Female, this one. Sergeant's stripes on her sleeve. She approached without rushing, surveying the scene like someone reviewing work already in progress. "What do we have?" The first officer, Garrett, she had read his nameplate by now, Wade Garrett, 12-year veteran, 3 prior complaints, the subject of the hearing she had been preparing for all evening, answered without loosening his grip. "Stolen vehicle, matching profile. She's got documentation, but it looks fake." "The documentation is not fake." She kept her voice level. "Data, not emotion. Dispatch can confirm the registration. The vehicle belongs to me." The sergeant didn't respond to her, didn't look at her, spoke only to Garrett, as if Meredith were furniture, scenery, an object rather than a person. "Has dispatch confirmed?" "They're running it now." As if on cue, the cruiser radio crackled. The voice of the dispatcher, female, bored, reciting information that should have ended this encounter. "Unit 47, dispatch shows vehicle registration valid. Repeat, registration valid. Owner matches license presented. No warrants, no flags." There it was, the verification, the proof, the official confirmation that no crime had been committed, no basis existed for detention, no justification supported what was happening to her body pressed against this car. Garrett didn't move. The sergeant didn't order him to stand down. Instead, she shrugged. A small motion, almost imperceptible, that communicated more than any words. The shrug of institutional solidarity. The shrug that said, "We take care of our own, and you are not our own." "Process her fully," the sergeant said. "Document everything by the book. If there's an issue with the documentation, we'll let processing sort it out." "There is no issue with the documentation." Meredith's voice remained level, but something had entered it now. An edge. The edge of someone who understood exactly what was happening and why. "Dispatch just confirmed. This stop has no legal basis." Garrett leaned close. The coffee smell again. The breath of someone who had decided she was guilty and would not be persuaded otherwise by evidence, by protocol, by law. "People like you always think you can drive cars like this. Nice clothes, nice car, but I know exactly what I'm looking at." People like you. The phrase hung in the summer air. The confession disguised as accusation. The admission of what this had always been about, wrapped in the authority of a badge and a gun, and the institutional power to make your reality disappear beneath paperwork and procedure. "I'd like your badge number," she said, "and your supervisor's name." Garrett laughed. Not a real laugh. A performed one. The kind designed to belittle, to dismiss, to remind her that her requests meant nothing here. "You'll get plenty of documentation at booking." He stepped back, adjusted his grip, produced handcuffs. "On your knees." She could have resisted, could have invoked her rights, could have demanded a supervisor beyond the sergeant who clearly had no intention of intervening, could have escalated in 100 ways that the law technically permitted. But the law technically permitted didn't count for much on the shoulder of Interstate 285 at 11:47 p.m. with 2 officers who had already decided what they were looking at. She lowered herself to the asphalt. The surface burned through her slacks. The kneeling position pressed her weight forward onto joints that weren't designed for pavement. She placed her hands behind her head, fingers interlaced, the position she had seen in 1,000 booking photographs, the position of submission, of compliance, of survival. Garrett took his time with the handcuffs, ratcheted them tighter than necessary, let the metal bite into her wrists. "Stay down," he said. Not because she was going anywhere, just because he could say it, because authority tastes sweetest when it's exercised for no reason beyond the exercise itself. She knelt, counted. 1, 2, 112, 113, 4 minutes and 17 seconds. She would learn the exact duration later, when evidence was cataloged and footage was reviewed. But in the moment, time stretched and compressed simultaneously, each second an hour, each minute a lifetime. Cars passed on the highway, headlights sweeping across the tableau, a black woman kneeling on asphalt, 2 officers standing over her, blue and red lights painting the scene in shifting colors. Did anyone slow down? Did anyone think something was wrong? Did anyone consider stopping, calling, intervening? If they did, they didn't act. They drove on, the way people always drove on, the way people had been driving on for 400 years. The sergeant's radio crackled again. Unit 47, be advised. Complainant on the Garrett incident is on the line. Claims documentation is valid. Wants supervisor contact. Someone had called. Someone in a passing car. Someone who had seen and felt something was wrong and found the courage to act. The sergeant keyed her radio. Copy dispatch. Tell complainant the situation is under control. Officers are following standard procedure. Standard procedure. The words should have been reassuring. They were designed to be reassuring. But standard procedure had put her on her knees on burning asphalt. Standard procedure had ignored dispatch confirmation of valid registration. Standard procedure had produced handcuffs and kneeling and people like you. Standard procedure was the problem. Finally, Garrett pulled her to her feet. Not gently. A yank that wrenched her shoulders, the handcuffs biting deeper as the metal took her weight. Let's go. They put her in the back of the cruiser. The seat was hard plastic, designed for suspects, designed to be hosed clean of whatever suspects left behind. She sat with her hands cuffed behind her, the metal digging into her spine, watching through the mesh divider as Garrett returned to her Camry. He searched it, thoroughly, opened the glove compartment, rifled through the console, checked under the seats, examined her briefcase, her judicial briefcase containing the Garrett file, the notes on his pending case, the evidence she had been reviewing when he didn't know she existed. He found nothing. Of course he found nothing. There was nothing to find. But he kept searching anyway, because the search wasn't about finding, it was about violating, about demonstrating that her property, her privacy, her dignity existed at his discretion, could be revoked at his whim, meant nothing unless he decided it meant something. She watched. She remembered. She stored every detail in the filing cabinet of her memory, the one she had built over years of depositions and cross-examinations and witness interviews, the one that could retrieve facts months or years later, exact and undiminished. This would come back. All of it. Every word, every gesture, every choice he made tonight. He just didn't know it yet. The ride to the county jail took 17 minutes. She knew because she counted. Because counting was the only power she had left in this situation. The power to observe, to document, to remember. The intake facility was fluorescent and concrete, the architecture of institutional indifference. They walked her through processing like she was anyone, like she was no one. Fingerprints, photograph, the inventory of her possessions, purse, phone, briefcase, jewelry. Charges? The processing officer asked without looking up. Fingers poised over a keyboard worn smooth by years of the same questions. Garrett answered. Driving stolen vehicle, presenting fraudulent documents, resisting arrest. She spoke for the first time since the kneeling. I did not resist. Your body cam will confirm that. Something flickered across Garrett's face. A micro-expression she almost missed. The tell of someone caught off balance, recovering quickly, filing the response away for later consideration. Camera malfunctioned. His voice was flat, rehearsed. Equipment issues. It happens. Equipment issues. The same phrase from the Jordan Williams file. The same excuse. The same convenient failure of the technology designed to protect citizens from exactly this kind of encounter. She noted it, filed it, added it to the case she was building in her mind, the case that would grow larger before it grew smaller, the case that would eventually consume careers and expose patterns and change, maybe, Something small about the system that had put her in handcuffs for driving her own car home from work. They led her to a holding cell, concrete walls, metal bench, fluorescent light that buzzed at a frequency designed to prevent sleep. One other occupant, a woman in her 40s, unconscious on the bench, sleeping off intoxication, oblivious to everything. The cell door closed. Metal on metal. The sound of finality that wasn't final because nothing was ever final. Not really. Not when you understood how systems worked and how systems could be made to answer for themselves. She sat on the far end of the bench, still wearing her $800 suit, still smelling faintly of the courthouse, of paper and leather and old wood, still carrying herself like someone who belonged elsewhere, because she did belong elsewhere, because this was wrong, because wrong things happened to people like her every day in this country, and would keep happening until enough receipts accumulated to force change. She closed her eyes. Not to sleep, to think. The timeline reconstructed itself in her memory with the precision she had cultivated over decades. 11:32 p.m. Lights appeared in mirror. 11:34. Pulled to shoulder. 11:36. First contact with Garrett. 11:38. Backup requested. 11:39. Dispatch confirmed valid registration. 11:41. Ordered out of vehicle. 11:43. Face against car. 11:45. Sergeant arrived. 11:47. Forced to kneel. 11:51. Handcuffs applied. 11:52. Placed in cruiser. Every timestamp mattered. Every gap between request and confirmation. Every deviation from protocol. Garrett had requested backup before dispatch confirmed the registration was valid. He had ordered her out of the vehicle after dispatch confirmed. He had arrested her despite confirmation. Each decision was a choice. Each choice was documented somewhere, in radio logs, in CAD records, in the digital footprints that modern policing left whether officers wanted them or not. The body cam had malfunctioned, but body cams were only one system. There were others. Collar microphones that fed to separate servers, dash cams in cruisers, civilian witnesses with cell phones. The panopticon of modern surveillance cut both ways. It watched citizens, yes, but it also watched those who watched citizens. And sometimes, not often enough, but sometimes, it caught the watchers in acts they thought no one would see. She would find out what it had caught tonight. But first, she had to survive tonight. She was allowed one phone call, standard procedure, the phrase that had become bitter on her tongue. She dialed from the wall phone in the corridor, an officer supervising, making sure she didn't say anything problematic. Ethan answered on the second ring, his voice fuzzy with interrupted sleep, sharpening instantly when he registered who was calling. "Meredith, it's almost 1 a.m. where—" Listen carefully. She kept her voice low, controlled, the voice of someone transmitting critical information under observation. "Don't say anything. Don't come to the station. Don't call anyone. Meet me at the courthouse tomorrow at 8:45 a.m., main courtroom. I'll explain everything then. Trust me." Pause. She could hear him processing, the legal mind engaging, recognizing that she was constrained in what she could say, trusting that she had reasons for what she wasn't saying. "Are you safe?" "I will be. I love you." She hung up before he could ask more questions, returned to the cell, sat back down on the metal bench. The drunk woman snored. The fluorescent light buzzed. The toilet in the corner dripped with metronomic regularity. She closed her eyes again. Not to sleep, to wait. Morning came the way mornings come in holding cells, announced by shift change rather than sunlight, by the clanking of keys rather than the singing of birds. She had not slept, had not tried. The night had passed in a state of active stillness, her mind working while her body remained motionless, building the case she would pursue once she left this concrete box. 6:47 a.m. An officer appeared at the cell door. Different officer than Garrett. Different shift. Different face delivering news that should have been delivered 8 hours ago. "You're being released. Charges pending review. No apology, no explanation." No acknowledgement that she had spent a night in jail for crimes that didn't exist, based on evidence that was fabricated, based on assumptions that had nothing to do with law and everything to do with the color of her skin. She collected her possessions, signed the release form, walked through the doors of the county facility into morning air that smelled like freedom, only because anything smelled like freedom after a night in a place designed to make you feel like you didn't deserve freedom. A taxi took her home. She could have called Ethan, could have waited for him to come. But she needed the transit time, the decompression, the opportunity to sit alone with her thoughts and prepare for what came next. The house was quiet when she arrived. Ethan's car in the driveway, but no sign of him at the window, no sound of movement inside. He was waiting, giving her space, trusting as she had asked. She went upstairs, showered, let the water run hot enough to scald, washing away the residue of concrete and institutional soap and the particular grime of being treated as something less than human. She stood under the spray until her skin turned pink, until the water began to cool, until she felt, not clean exactly, but cleaner, closer to herself. Fresh clothes, professional clothes, the armor of competence that would carry her through what came next. Ethan waited in the kitchen, coffee made, 2 cups on the counter, his and hers, as always. He looked at her with the expression she had seen only a handful of times in their 19 years together, the expression of someone who loved her beyond measure and was terrified of what that love might be asked to endure. "Last night," she said, accepting the coffee, letting it warm her hands, "Officer Wade Garrett arrested me for driving my own car. He claimed it was stolen. Dispatch confirmed it wasn't. He arrested me anyway. Then he charged me with impersonating a public official." Ethan's face moved through stages of reaction. Disbelief, rage, calculation. The legal mind engaging even through the husband's fury. "We sue. Immediate. Certain. Federal civil rights violation. Section 1983. I'll have papers filed by—" "No." Her voice was firm. "Final. Not yet. Meredith, they falsely arrested you. That's—" "I know what it is." She set down the coffee, met his eyes, let him see what was behind the composure, the controlled fury that would fuel everything to come. "But I'm handling this my way. Meet me at the courthouse at 8:45. Main courtroom. You'll understand then." He studied her face, the expression she wore when strategy had crystallized, when she saw a path forward that others couldn't see yet. "What are you planning?" "Justice," she said simply. She checked her watch. 7:30 a.m. An hour and 15 minutes until court, until the hearing she had been preparing for last night when all of this began. The Garrett case, his excessive force allegations, the pattern she had identified in the evidence. The universe had a sense of timing. She finished her coffee, gathered her briefcase, the same one Garrett had rifled through, still containing the same files, now containing something additional. Her own testimony, her own evidence, her own experience as proof of the pattern she had seen in paperwork and would now see in person. The courthouse. The drive that should have happened last night, completed this morning instead. The parking garage. The same spot. Third space from the elevator. She walked through the side entrance, avoided the main lobby, didn't want to see anyone yet, didn't want to explain. Her chambers. The door that read her name in tarnished brass. The space she had occupied for 15 years, dispensing justice according to laws that were supposed to protect everyone, but somehow kept failing people who looked like her. She sat at her desk, opened the Garrett file, read it for the 4th time with new eyes. Not judge's eyes anymore, victim's eyes. Because now, she wasn't just the judge assigned to his case. She was evidence. She was Exhibit A in a pattern she hadn't known she would become part of. The pattern was clear now, clearer than it had ever been. Jordan Williams, 17, forced to the ground, knee on his back for 3 minutes. 6 other complaints over 4 years, each one buried or dismissed, each one featuring similar elements. Stop without cause, escalation without provocation, force without justification, and always the same phrase appearing in reports: equipment malfunction. The phrase wasn't coincidence. It was strategy, a strategy she would expose. Her phone buzzed. Text from the bailiff. Courtroom ready. Parties arriving. She stood, put on her robes, checked her reflection in the small mirror on her wall. Composed. Professional. No visible sign of a night spent on a metal bench in a concrete cell. But beneath the robes and the composure and the professional mask, something burned, cold and calculating and patient. The fire of someone who had been wronged by a system she had dedicated her life to serving, and who would now make that system answer for itself. She picked up her gavel, felt its weight, the authority it represented, the power she had earned through decades of work that some people would never believe she deserved, no matter how many diplomas hung on her wall. She was about to walk into that courtroom, about to sit on that bench, about to see the officer who had arrested her 12 hours ago. And he had no idea. None. The walk from chambers to courtroom took 47 seconds. She had counted it once, years ago, out of the same impulse that led her to count everything, the need to know precisely how long each segment of her life required, the need to leave no room for uncertainty. Today she counted again. 1, 2, 46, 47. The side door opened onto the bench, the elevated platform where justice was supposed to sit, dispensing fairness and equity and all the ideals that had drawn her to law in the first place. The bailiff's voice. All rise. The United States District Court for the Northern District of Georgia is now in session. The Honorable Judge Meredith Holloway presiding. She entered, robes flowing, gavel in hand, the full weight of federal authority wrapped around her shoulders like the armor it was supposed to be. The courtroom rose, the ritual acknowledgement of the bench, of the system, of the law itself. She didn't look at the defense table, not yet, not immediately. Let the moment extend, let him wait. She settled into her chair, arranged papers on the bench, straightened her nameplate, adjusted her water glass. Every movement deliberate, controlled, the choreography of someone who understood the power of timing. Then she looked up. The defense table held 2 occupants, a man in an expensive suit, the defense attorney sent by the city to protect its interests, and beside him, in civilian clothes but with the bearing of law enforcement, Officer Wade Garrett. Their eyes met. Recognition didn't come slowly. It struck like lightning, electric and immediate. His face went through a transformation she would remember for the rest of her life. Confusion, calculation, dawning horror, the color draining from his skin like water from a sink, leaving something gray and terrified behind. His mouth opened. No sound emerged. His hand gripped the table edge, white-knuckled, holding on like the ground beneath him had disappeared. Because it had. She let him look, let him see, let him understand, finally, what he had been looking at last night on the shoulder of Interstate 285. Not a suspect, not a profile, not people like you. The judge who would decide his fate. This story is just getting started. If you want to see what happens when Officer Garrett faces the full weight of his actions, drop a like and stay tuned. Except she wouldn't decide his fate. Not directly. The law had rules for situations like this, rules she had spent her career upholding even when they complicated her desires. 28 U.S.C. Section 455. A judge must recuse herself when she is a witness, a victim, or has personal knowledge of disputed facts. She was all 3 now. But before she recused, before she transferred this case to another judge who would handle it with appropriate distance, she had something to do. Something the law not only permitted, but required. She had to disclose. Before we proceed, she said, her voice carrying through the courtroom with the clarity that came from years of practice, I must make a disclosure to the court pursuant to 28 U.S.C. Section 455. Garrett's head snapped up. Whatever color remained in his face fled. His attorney leaned over, whispering urgently, But Garrett wasn't listening. Couldn't listen. Could only stare at the woman in the robes who was about to end his world. The courtroom waited. The plaintiff's table. The gallery filling with observers who had come to witness an excessive force hearing and were about to witness something they would talk about for years. She let the silence extend. 3 seconds, 4, an eternity in courtroom time. Then she spoke. Last night at approximately 11:47 p.m., I was subjected to a traffic stop on Interstate 285. The officer who conducted that stop was Officer Wade Garrett, the defendant in this case. Murmurs from the gallery, the sound of comprehension spreading like ripples in water. During that stop, I was ordered to kneel on the roadway. I was handcuffed. I was transported to county intake, where I was held for approximately 7 hours before being released without charges. At no point did I resist. At no point did I provide false documentation. The vehicle in question was and is legally registered in my name, as dispatch confirmed during the stop itself. The murmurs became exclamations. Someone in the gallery said "Holy cow" loudly enough to carry. The bailiff moved forward, prepared to call for order. She continued before order could be called. Officer Garrett stated during the stop, and I quote, "People like you always think you can drive cars like this. I know exactly what I'm looking at." She paused. Let the words settle. Let the gallery absorb their meaning. I am therefore a witness and potential victim in matters related to Officer Garrett's conduct. I am legally required to recuse myself from this proceeding. Garrett's attorney stood, finally finding his voice, finally trying to regain some control over a situation that had spiraled beyond anyone's preparation. Your Honor, with respect, this is highly irregular. The defense would request a recess to... Denied. The word came out sharp. Absolute. I have not finished my disclosure. The attorney sat. Garrett had stopped looking at her. His eyes were fixed on the table, on his hands, on anything except the face of the woman he had forced to kneel 12 hours ago. Before I transfer this case, I am entering into the record my formal statement regarding the events of last night. This statement will be available to whatever judge assumes this matter, as well as to any related proceedings that may arise. She picked up a document from the bench. The statement she had typed this morning, in her chambers, while the courthouse was still quiet and the weight of last night was still fresh enough to fuel precision. She began to read. At approximately 11:32 p.m. on the evening in question, I observed a patrol vehicle approaching at high speed in my rearview mirror. I was traveling at 63 miles per hour in a 65 zone. I had committed no traffic violation. I signaled and pulled to the shoulder of the highway. At 11:34 p.m., I stopped the vehicle and placed my hands at 10 and 2 on the steering wheel. I lowered my window before the officer approached. I announced each movement before making it, consistent with guidelines for safe interaction with law enforcement. At 11:36 p.m., Officer Garrett reached my window. He demanded license and registration without greeting, without explanation for the stop, and without providing his badge number or name. I provided the requested documents and informed him that the vehicle was mine. At 11:38 p.m., Officer Garrett returned to his cruiser. At 11:39 p.m., dispatch confirmed over the radio, clearly audible to me, that my registration was valid, that I was the registered owner, and that no warrants or flags existed. Officer Garrett disregarded this confirmation. At 11:41 p.m., Officer Garrett ordered me to exit the vehicle. I complied. I was immediately grabbed by the arm with excessive force and spun to face my vehicle. My face was pressed against the roof of the car. A second patrol unit arrived at this time. At 11:43 p.m., Sergeant Dana Pruitt approached. She was informed of dispatch's confirmation that my documentation was valid. She ordered Officer Garrett to, quote, process her fully and document everything by the book, despite the absence of any legal basis for arrest. At 11:47 p.m., Officer Garrett ordered me to kneel on the roadway. I complied. I remained in that position for 4 minutes and 17 seconds. During this time, Officer Garrett stated, "People like you always think you can drive cars like this. I know exactly what I'm looking at." At 11:51 p.m., I was handcuffed. The handcuffs were applied with excessive tightness, leaving marks on my wrists that remain visible this morning. At 11:52 p.m., I was placed in the patrol vehicle. During the drive to county intake, Officer Garrett made additional comments regarding my appearance, my vehicle, and his certainty that I had acquired the vehicle through illegal means. These comments are consistent with racial profiling and bias-based policing. At intake, I inquired about body cam footage. Officer Garrett stated that his camera had, quote, malfunctioned, and that no video existed. I note for the record that this claim of equipment malfunction is identical to claims made in previous complaints against Officer Garrett, including the complaint at issue in this case. I was released at 6:47 a.m. with charges, quote, pending review. No charges have been filed because no charges can be legitimately filed. I committed no crime. I violated no law. I was arrested because I am a black woman driving a car that an officer decided I should not be driving. She set down the document. The courtroom was silent, the kind of silence that follows an explosion, when ears are still ringing and minds are still processing. Garrett hadn't moved, hadn't looked up. His attorney sat frozen, the posture of someone whose case had just collapsed around him. Meredith spoke once more. This statement is entered into the record. This case is transferred to Judge Raymond Ashworth, who will assume jurisdiction effective immediately. All future hearings will be scheduled through his chambers. She picked up her gavel, raised it. Court is in recess. The gavel fell. She stood, turned, walked toward the side door. Behind her, the courtroom erupted. Voices, exclamations, the sound of reporters reaching for phones, the chaos of a story breaking in real time. She didn't look back. The door closed behind her. She walked the 47 seconds back to her chambers. 1, 2, 46, 47. Inside, she closed the door, locked it, sat down in her chair. And then, only then, in the privacy of walls that had witnessed 15 years of her labor, she allowed herself to feel. The fury she had contained through 14 hours of humiliation and procedure and strategic patience, the grief for every person who had experienced what she experienced and had no robes to put on afterward, no bench to speak from, no power to make their truth part of an official record. The determination that this would not end here, that Officer Wade Garrett was only the beginning, that the system that had protected him would be forced to account for every failure that had led to last night. Her phone buzzed. Julian, the voicemail will be full in 10 minutes. Every reporter in Atlanta is calling. What do you want me to tell them? She typed back, tell them I'll have a statement when the time is right. For now, no comment. For now. Because the disclosure was just the first step. The recusal was just the beginning. The real work, the investigation, the evidence gathering, the systematic dismantling of the protections that allowed officers like Garrett to operate with impunity, that work was only starting. She pulled up her contacts, found the number for Detective Yvonne Tate, Internal Affairs. 18 years investigating officers who thought they were above accountability. The kind of investigator who didn't accept equipment malfunction as an explanation. She typed a message. Detective Tate, this is Judge Meredith Holloway. I have a complaint to file. I also have information relevant to the Garrett case that's about to land on your desk. Can we meet today? The response came in 30 seconds. I saw the news. I was about to contact you. My office, 2 p.m. Confirmed. She set down the phone. Outside her window, the city of Atlanta continued its morning. Traffic flowed. People worked. The machinery of ordinary life grinding forward as if nothing extraordinary had happened. But something had happened. Something was continuing to happen. And something would keep happening until the full weight of what Officer Wade Garrett had done, and what the system had allowed him to do, became impossible to ignore. She had receipts. She had a platform. She had 15 years of judicial experience and a lifetime of surviving in spaces that weren't designed for her survival. She had, in other words, everything she needed to turn a traffic stop into a reckoning. The meeting with Detective Tate would be the second step. The internal affairs investigation would be the third. The federal inquiry, because this would become federal, she was certain of that now, would be the fourth. And somewhere down that road, Officer Wade Garrett would learn exactly how much his assumptions had cost him. He thought he knew what he was looking at last night on the shoulder of Interstate 285. He had no idea. 2 p.m. arrived the way institutional time always arrived, slowly until it didn't, then all at once. The Internal Affairs Office occupied a building 3 miles from the main precinct, deliberately separated from the department it investigated, a structural acknowledgement that accountability required distance. Detective Yvonne Tate met her in the lobby. 18 years of IA work had carved themselves into her face, the particular wariness of someone who had heard every excuse, investigated every cover-up, documented every failure the system produced. She was tall, angular, her hair graying at the temples in a way she made no effort to hide. Her handshake was firm without being aggressive. "Judge Holloway, thank you for coming in." "Thank you for seeing me on short notice." They walked through corridors that smelled like every government building Meredith had ever entered. Old coffee, recycled air, the particular mustiness of bureaucracy. Tate's office was small but organized, files arranged with military precision. A whiteboard on one wall covered in names and dates and connecting lines. Some of those lines led to Garrett Wade, Meredith noticed. Said nothing. Sat in the chair Tate indicated. "I've reviewed your statement from this morning's hearing," Tate began. "I've also pulled the dispatch logs from last night. They confirm what you described. Valid registration confirmed at 11:39 p.m. Arrest proceeded at 11:41. 2 minutes after confirmation that no crime had been committed." "Correct." Tate opened a file. "This is the third complaint against Officer Garrett this year, 6th in 4 years. Same pattern in each one. Minority driver, late night, vehicle allegedly matching a profile, body cam conveniently unavailable." Meredith leaned forward. "The body cam claim. Is there any evidence it actually malfunctions, or—" "That's what I wanted to discuss." Tate pulled up something on her computer, turned the monitor so Meredith could see. Body cams in this department feed to 2 separate systems. Video goes to one server, audio from the caller mic goes to another. Most officers don't realize the audio backup exists. It was implemented 2 years ago after a federal audit found suspicious gaps in footage. "Are you saying—" "I'm saying Officer Garrett's body cam video is indeed missing from last night. Equipment malfunction according to his report. But the caller mic audio is intact, all 47 minutes of it." The words settled over the room like a verdict. 47 minutes. Every word, every command, every "people like you," and "I know what I'm looking at." "I'd like to hear it," Meredith said. "I thought you might." Tate clicked play. The audio was tinny but clear. The sound of an engine, road noise. Then Garrett's voice, unmistakable. "License and registration." Her own voice, distant but recognizable. "My license is in my purse, which is on the passenger seat. My registration is in the glove compartment. I'm going to reach for them now, slowly." The encounter played out in compressed time. Her compliance, his escalation, the dispatch confirmation he ignored, the sergeant's arrival, the order to kneel. Then the words that would define everything. "People like you always think you can drive cars like this. I know exactly what I'm looking at." Tate stopped the playback. The silence that followed was heavy with implication. "That's not equipment malfunction," Meredith said. "That's evidence. That's a pattern." Tate pulled another file. "Jordan Williams, the plaintiff in the case you were assigned. His stop has identical elements. Late night, vehicle supposedly matching a profile, body cam malfunction, excessive force. The only difference is Jordan Williams was 17 and had no platform to tell his story from. Until now. Until now." Tate closed the file. "Judge Holloway, I have to be direct with you. Internal Affairs can investigate. We can document. We can recommend discipline. But what we can't do is guarantee outcomes. The police union has excellent attorneys. Qualified immunity protects officers in civil cases. And in my 18 years, I've seen exactly 4 officers terminated for excessive force complaints. 4. I'm not looking for termination. Meredith met Tate's eyes. I'm looking for accountability, whatever form that takes. Then you should know something else. Tate turned to her whiteboard, pointed to a name connected to Garrett's by a red line. Lieutenant Marcus Devlin, watch commander the night you were arrested. He signed off on Garrett's paperwork without reviewing the dispatch logs. Standard practice for him, he doesn't verify, he just processes. And this morning, he sent an email to all watch commanders. What kind of email? Tate pulled up another screen. Read aloud. From Lieutenant M. Devlin to watch commanders. Subject, Garrett complaint. Message, coordinate statements before IA interviews. Standard language, isolated incident. Training opportunity. Coordinate statements. The words hung in the air, the explicit instruction to align stories before investigation. The institutional reflex to protect its own before protecting the public it served. That email wasn't supposed to be forwarded to me, Tate said, but someone in the department has a conscience. I received it anonymously at 9:47 this morning. Someone inside is helping. Someone inside is scared. Tate leaned back. Whatever happens next, Judge Holloway, it won't be quick, it won't be clean, and it won't be complete. That's the reality of accountability and systems designed to resist it. I understand. Meredith stood. But incomplete accountability is better than none. And sometimes incomplete accountability is the foundation for something more. She extended her hand. Tate shook it. I'll be in touch, Tate said. The formal investigation opens today. We'll need your testimony, detailed, multiple interviews. The process takes months, sometimes longer. I've waited longer for less. She walked out of the IA building into afternoon sunlight. The heat wrapped around her like the city itself was offering an embrace or issuing a warning. Her phone buzzed, a text from a number she didn't recognize. I have dash cam footage. I saw what happened. How do I get it to the right people? She stared at the message. A witness. Someone who had passed on the highway, who had seen her kneeling, who had captured what the body cam conveniently missed. She typed back, upload to a cloud server. Send the link to Detective Yvonne Tate, Internal Affairs. She'll know what to do with it. The response came seconds later. Done. I hope this helps. What they did to you was wrong. She didn't reply. Didn't need to. The witness had done what witnesses could do, provided evidence. The rest, the investigation, the prosecution, the slow grinding machinery of justice, would take care of itself. Or it wouldn't. That was the nature of the system. It promised fairness, but delivered outcomes shaped by power. It offered procedure, but produced results influenced by who you knew and who you were. But sometimes, not often, but sometimes, the receipts accumulated past the point of denial. Sometimes the evidence became so overwhelming that even systems designed to resist accountability found themselves accountable anyway. She was going to find out which kind of sometimes this was. The days that followed moved with the particular rhythm of investigation. Hurry up and wait. Bursts of activity followed by silence, the accumulation of evidence building toward something that might become consequence or might become another file in a drawer marked unresolved. Detective Tate worked methodically, interviews scheduled, statements taken, the caller mic audio transcribed and analyzed, the civilian dashcam footage retrieved from the cloud server and authenticated, 4 minutes and 17 seconds of a black woman kneeling on asphalt, while 2 officers stood over her and traffic passed indifferently on the highway beyond. Lieutenant Devlin's emails continued to surface. Not just the one about coordinating statements. Others emerged, older ones, revealing a pattern of institutional protection that stretched back years. Forwarded anonymously. Someone inside the department feeding information to IA, risking career and possibly safety to expose what the system wanted hidden. The media circled. Reporters requested interviews. News vans parked outside the courthouse. The story had legs. Federal judge arrested during traffic stop would have been news regardless, but federal judge forced to kneel after dispatch. confirms valid registration. That was the kind of story that traveled. National outlets picked it up. Legal commentators analyzed it. The phrase equipment malfunction became shorthand for something larger, something rotten, something too many people recognized from their own encounters. Meredith declined all interview requests. The time wasn't right. The investigation was ongoing, and she had learned, over years of working within systems, that speaking too soon could give the system ammunition to discredit you. If this case is making your blood boil, wait until you see what the investigation uncovers. Subscribe so you do not miss a single twist in this story. Instead, she worked. Took the cases Judge Ashworth didn't assume. Reviewed briefs. Wrote opinions. Maintained the discipline of routine because routine was the scaffold that held everything else in place. 3 days after her testimony to IA, a new development arrived in her email. From AUSA Franklin Marsh, DOJ Civil Rights Division. Subject: Formal Notification. 18 U.S.C. Section 242 Investigation. The body of the email was bureaucratic. Formal language notifying her that the Department of Justice had opened an investigation into potential violations of federal civil rights law related to her traffic stop. Her testimony would be required. Her cooperation was requested. The investigation would proceed in parallel with local IA inquiry. 18 U.S.C. Section 242. Deprivation of rights under color of law. The federal statute that made it a crime for anyone acting under government authority to willfully deprive a person of their constitutional rights. Maximum penalty: 10 years in federal prison. She read the email 3 times. Let the implications settle. This was no longer just an internal affairs investigation. This was federal, DOJ. The machinery that had brought down corrupt officials and civil rights violators across the country for decades. Garrett had thought he was dealing with just another driver, just another profile, just another person whose rights could be violated with impunity because the system would protect him the way it always had. He had been wrong. Her phone rang. Marcus Jr., her brother, retired Army JAG colonel, 22 years of military justice experience before transitioning to civilian consulting. Saw the DOJ notification made the news. His voice carried the particular calm of someone who had seen wars and courtrooms and understood that both required patience. How are you holding up? I'm holding. That's what I figured. Listen, I made some calls. Franklin Marsh is good, thorough. He doesn't open investigations he can't close. If he's on this, it's because he sees a path to prosecution. A path isn't a guarantee. No, but it's more than most people get. Pause. You know this is going to get harder before it gets easier. The union will fight. The city will stall. Garrett will claim he followed procedure. They always do. Let them claim. She looked out her office window at the Atlanta skyline. I have receipts. That you do. Marcus's voice warmed slightly, something almost like pride. For what it's worth, Dad would be proud. Fighting from inside the system the way you're fighting. He always said that's where the real battles happen. Their father. 30 years as a public defender before heart disease took him. A man who believed in institutions, even when institutions failed him. Who taught his children that you changed systems by mastering them, not abandoning them. I know, she said. I think about him every day. She hung up, returned to the work waiting on her desk. The cases that needed attention, regardless of what was happening in her personal life. The discipline of compartmentalization that had served her for decades. But somewhere in the back of her mind, a clock continued ticking. The clock that had started on the shoulder of Interstate 285. The clock that measured the distance between violation and vindication. The clock that Officer Wade Garrett didn't know existed, but would. Soon. A week passed, then 2. The investigation progressed in the way investigations progress. Interviews and document requests, and the slow assembly of a case file thick enough to support whatever decision the prosecutors eventually made. Garrett was placed on administrative leave, paid, standard procedure pending investigation. He would continue collecting his salary, while IA and DOJ determined whether his actions constituted crimes. Sergeant Pruitt was also placed on leave. Her authorization of the arrest, despite dispatch confirmation, had drawn scrutiny. Her statement to investigators, that she trusted Officer Garrett's judgment based on his 12 years of experience, did not play well against the audio recording of his judgment. Lieutenant Devlin remained on duty, transferred from watch commander to administrative role, but still employed, still drawing his salary, still walking the halls of a department that had not yet decided whether coordinating false statements constituted misconduct. The civilian dashcam footage went public, uploaded by an anonymous source to 3 news outlets simultaneously. 4 minutes and 17 seconds of truth that no amount of equipment malfunction could erase. Meredith watched the coverage from her chambers. The footage wasn't graphic. No violence, no blood, nothing that would trigger content warnings. Just a woman on her knees, hands behind her head, officers standing over her. The tableau of power and powerlessness that played out every day on American roads, finally visible to the millions who usually drove past. The comment sections exploded. Support. Outrage. The predictable contingent claiming she must have done something to deserve it, must have resisted, must have provoked. The equally predictable contingent sharing their own stories of stops that went wrong, encounters that escalated, assumptions that attached to skin color before any action could prove them false. This is America, she thought. This is the country I serve as a judge, the country that made me and that I must make better. Her phone buzzed. Detective Tate. The grand jury is convening next week. AUSA Marsh is presenting evidence. He wants to know if you're available to testify. When and where? Wednesday. Federal Courthouse, 9 a.m. I'll be there. She hung up, added the date to her calendar, continued working through the files on her desk. The grand jury, the next step in the process. The determination of whether enough evidence existed to indict, to formally charge, to begin the journey toward trial that might result in something resembling justice. Might not, too. Grand juries could decline to indict. Prosecutors could recommend against charges. Judges could dismiss cases on procedural grounds. Officers could invoke qualified immunity and walk away from civil suits. The system had 1,000 escape hatches for those it chose to protect. But this time felt different. This time, there were receipts. This time, there was a federal judge who understood exactly how the system worked and exactly how to work within it. This time, Officer Wade Garrett had picked the wrong person to put on her knees. Wednesday arrived. Meredith dressed in civilian clothes. No robes, no judicial signifiers. Today she was a witness, not an arbiter. A citizen who had experienced what millions of citizens experienced, elevated to visibility only because of the position she held. The federal grand jury room was familiar. She had testified before grand juries as a prosecutor decades ago, had presented evidence, had walked other witnesses through the process. The difference now was that she was the evidence, her experience, her memory, her body, which still carried faint marks on her wrists where the handcuffs had bitten too tight. AUSA Franklin Marsh met her outside the chamber, mid-40s, sharp suit, the bearing of someone who had prosecuted civil rights cases for 15 years and understood both the possibilities and the limitations. Judge Holloway, thank you for being here. Thank you for taking this seriously. I take all civil rights violations seriously, but this one, he paused, chose his words. This one has the potential to expose a pattern, not just one officer but a system. The evidence suggests Garrett didn't act alone. He acted with institutional support, supervisors who approved, lieutenants who coordinated, a department that looked the other way for years. I know. She had read the same evidence, had reached the same conclusions. That's why I'm here. They entered the grand jury room. 23 citizens seated in rows. The foreman at the front. A court reporter transcribing every word. She was sworn in, took her seat, began to testify. The story unfolded in the precise language she had cultivated over decades. Times, dates, locations, exact words spoken, exact responses given. The dispatch confirmation at 11:39. The arrest at 11:41. The kneeling that lasted 4 minutes and 17 seconds. She did not editorialize, did not speculate, did not add emotion to facts that spoke for themselves. She simply told the truth, the whole truth, and let the grand jury decide what that truth meant. The questioning lasted 2 hours. Marsh guided her through the timeline. The grand jurors asked their own questions. How did you feel when he said that? Did you consider resisting? Why didn't you identify yourself as a judge? She answered each one honestly. How did she feel? Angry, humiliated, determined to survive the encounter and pursue accountability afterward. Did she consider resisting? No. Resistance escalates. Escalation endangers. Survival requires compliance, even when compliance feels like defeat. Why didn't she identify herself? She did. Officer Garrett laughed, said she was being creative, said he was the president, dismissed her truth because it didn't fit his assumptions. The grand jury listened, took notes. The foreman's expression remained neutral throughout, the trained neutrality of someone who would not reveal which way he was leaning until the deliberation was complete. 2 hours and 17 minutes. She was excused, walked out of the grand jury room into a hallway where her brother waited, having driven up from Savannah for the occasion. How did it go? I told the truth. The rest is up to them. They walked out of the courthouse together, into afternoon sunlight that felt different somehow. Cleaner, like something had shifted even if the shift wasn't yet visible. The grand jury would deliberate, would decide whether to indict, would issue its decision in the coming days or weeks or however long the process required. And whatever that decision was, Meredith would accept it, would continue her work, would keep fighting from inside the system because that was where she had always fought, where her father had fought, where generations of black professionals had fought to make institutions live up to the ideals they claimed to serve. But she allowed herself one moment of hope, one breath of anticipation, the possibility that this time, finally, the receipts would matter, the evidence would count, the truth would outweigh the institutional reflexes that had protected officers like Garrett for so long. One moment. Then she returned to her life, her cases, her routine, the scaffold of discipline that held everything else in place. The waiting continued. But some waits were worth enduring, and some truths once spoken could not be unheard. The grand jury returned its decision on a Thursday, 11 days after her testimony. 11 days that had stretched like elastic, each hour weighted with the knowledge that lives were being decided in a room she couldn't enter, by people she would never know. AUSA Marsh called at 4:17 p.m., his voice professional, but something underneath, satisfaction perhaps, or vindication, leaked through. Indictments returned. Officer Wade Garrett, 2 counts under 18 U.S.C., Section 242. Sergeant Dana Pruitt, 1 count, accessory to deprivation of rights. Both will be arrested this evening and arraigned tomorrow morning. She let the words settle, processed them, added them to the mental file that had been building since the night her knees hit asphalt. What about Devlin? Pause. Insufficient evidence of direct participation. The emails suggest coordination, but we couldn't establish that he knew the statements he was helping coordinate were false. He's been referred to internal affairs for administrative action, but criminal charges aren't viable at this time. Not viable. The words of institutional limitation, the system protecting its own, even as it sacrificed others. And the department itself? The grand jury recommended opening a pattern or practice investigation. I've forwarded the recommendation to my superiors. If they approve, we'll be looking at the entire department, not just individual officers. Pattern or practice. The language of 42 U.S.C., Section 104141, the authority that allowed the Department of Justice to investigate law enforcement agencies engaged in systematic civil rights violations. Consent decrees, federal monitors, the machinery of forced institutional change that had transformed departments in Ferguson, Baltimore, Chicago. "Thank you for the update," she said, "and thank you for your work on this. Thank you for your testimony, for your courage." Marsh paused. "Most people who experience what you experienced don't have the platform to make themselves heard, don't have the knowledge to navigate the system, don't have the resources to fight back. You had all three. You used them. That matters." She hung up. Sat in her chambers as the afternoon light shifted through the window. Garrett would be arrested tonight. Arraigned tomorrow. Tried eventually, months or years from now, in a federal courtroom where another judge would preside and another jury would decide. Pruitt would face the same process. Shorter, perhaps. She might plea, might cooperate, might provide testimony against Garrett in exchange for reduced charges. Devlin would escape criminal accountability, would face administrative hearings and possibly termination, probably transfer, maybe nothing at all. The system would grind forward. Some justice would be achieved, some justice would be denied. The outcome would be partial, incomplete, unsatisfying. But it was something more than the countless victims before her had received. Something that might, if the pattern or practice investigation moved forward, become the foundation for genuine change. She picked up her phone, called Ethan. Indictments returned, Garrett and Pruitt both. His exhale was audible. Relief and release and 19 years of partnership compressed into a single breath. "How do you feel?" She considered the question. How did she feel? The easy answers, vindicated, satisfied, triumphant, didn't quite fit. The reality was messier, more complex. "I feel like we won a battle in a war that won't end in my lifetime. Like something small changed, but something large stayed the same. Like I did what I could with the power I had, and now I wait to see what happens next." That's not nothing. No. She looked at the diplomas on her wall, the ones she never looked at, the proof she no longer needed to provide. That's not nothing. She went home that evening, cooked dinner with Ethan, watched the news coverage of Garrett's arrest. Perp walk, handcuffs, the particular humiliation of power revoked. The same humiliation she had experienced, reversed and returned. She didn't feel satisfaction watching it. She felt tired of a system that required individual catastrophe to motivate institutional change. Tired of being the exceptional case that proved the rule. Tired of the knowledge that for every Meredith Holloway who had the platform to fight back, there were thousands who didn't. Hundreds of thousands. Millions. But tired didn't mean defeated. Tired meant human. And tomorrow, she would put on her robes and take her place on the bench and continue the work she had been doing for 15 years. Dispensing justice case by case. Building precedent decision by decision. Trying to make the system better from the inside, because that was where she had always worked, and where she would always work, and where the change happened slowest, but lasted longest. The investigation would continue. The trial would happen eventually. The outcome would be partial, and she would keep fighting anyway. Because that was what you did when you understood how systems worked. You didn't expect perfection. You didn't demand overnight transformation. You accumulated receipts. You documented patterns. You built cases that became undeniable. And when the moment came, when the evidence was overwhelming and the platform was available and the witnesses were credible, you pressed forward and accepted whatever partial justice the system was willing to yield. Then you started again, and again, and again, until the system had no choice but to change. The arraignment was scheduled for 9 a.m. Friday. Federal courthouse. Same building where Meredith dispensed justice daily. Different courtroom, different judge. But the same halls, the same marble, the same echoing footsteps of attorneys and defendants, and the endless human machinery of the law. She didn't attend. Couldn't attend. Her presence would become a story, would distract from the proceeding, would turn the arraignment into spectacle rather than procedure. Instead, she worked, reviewed briefs, prepared for Monday's docket. The discipline of routine providing structure for a mind that wanted to wander toward other courtrooms and other outcomes. Julian brought updates throughout the morning, Information gleaned from the clerk's network that connected every courthouse employee in a web of informal intelligence. Garrett's attorney requested bail. Prosecutor opposed. Judge set bond at $200,000. She nodded, continued reading. Pruitt's arraignment followed. She took the deal. She looked up. What deal? Cooperation agreement. Testimony against Garrett in exchange for reduced charges. Probation instead of prison. Pruitt was talking. Would tell investigators what she knew about Garrett's history. Would confirm the pattern that the evidence already suggested. Would provide the institutional insider perspective that made prosecution stick. The dominoes were falling. Not all of them. Devlin remained standing. Others in the department remained unnamed. The system protected its own even as it sacrificed individuals. But dominoes falling was progress. Dominoes falling meant accountability. Dominoes falling meant that the next officer considering whether to put a black woman on her knees might hesitate, might reconsider, might remember what happened to Wade Garrett, and decide the risk wasn't worth it. That was how change happened. Not through revelation, but through accumulation. Not through single dramatic moments, but through the steady accretion of consequences that made misconduct more costly than compliance. Friday became Saturday. Saturday became Sunday. Sunday became Monday, and the new week began, and the work continued, and the investigation progressed in the background, while the foreground remained filled with the ordinary business of federal court. 3 weeks after the arraignment, AUSA Marsh called with another update. The pattern or practice investigation has been approved. We're assigning a team. 18 months minimum. Federal monitor will be recommended if we find what we expect to find. 18 months. A year and a half of scrutiny, of document review and testimony, and the forensic examination of departmental culture. What do you expect to find? What we always find. Policies that exist on paper but not in practice. Training that happens once and is never reinforced. Supervisors who approve misconduct because approving is easier than investigating. A culture of impunity protected by silence and solidarity. She knew the pattern, had seen it in case files, had ruled on its consequences, the systemic rot that enabled individual failures. And the monitor? If we recommend one, and the city accepts, they'll have oversight of department operations for the duration. Reforms will be mandated. Compliance will be measured. Progress will be documented, or its absence will be documented instead. Consent decree. The heavy artillery of federal civil rights enforcement. The tool that had forced transformation in departments that refused to transform themselves. Keep me informed, she said. Always. She hung up, looked out her window at the city she served, the city that was about to be examined in ways it had avoided for decades. The clock was still ticking, the one that started on the shoulder of Interstate 285, the one that measured the distance between violation and vindication. That clock would keep ticking for years, would keep marking time through trials and appeals and policy reforms and the endless, slow work of institutional change. But it was ticking. That was what mattered. It was ticking, and Officer Wade Garrett finally knew exactly what he had been looking at that night. Not a suspect, not a profile, not someone whose rights could be violated without consequence. A woman who knew how the system worked, and who would make the system answer for itself. 6 months measured themselves in depositions and document requests, in court dates postponed and rescheduled, in the particular rhythm of federal prosecution that moved like continental drift, imperceptible day to day, undeniable over time. Meredith continued her work. Cases filled her docket. Opinions flowed from her chambers. The machinery of justice ground forward on matters unrelated to her own, demanding the attention and precision she had always given, regardless of what occupied the parallel track of her life. Garrett's trial date was set for April. Spring in Atlanta, when the dogwoods bloomed, and the city shed its winter gray, and the federal courthouse calendar cleared enough to accommodate a case that had drawn national attention. His defense team had grown. No longer just the city attorney's office. Private counsel had been retained, specialists in police defense work, attorneys who had built careers protecting officers from the consequences of their actions. They filed motions, challenged evidence, sought to suppress the collar mic audio on technical grounds that the court rejected, argued that Meredith's status as a federal judge had biased the investigation, that her platform had poisoned the jury pool, that a fair trial was impossible in a city where her face had appeared on every news broadcast for weeks. The motions failed. Each one. The evidence remained intact. The trial date held. Pruitt's cooperation proved valuable. Her testimony, given in exchange for probation and a resignation that preserved her pension, filled gaps the physical evidence couldn't reach. She described department culture with the specificity of an insider who had finally decided the institution wasn't worth protecting. The phrase "profile stop" appeared repeatedly in her statements. Not official terminology, nothing in departmental policy authorized stops based on race and vehicle value, but unofficial practice passed down through field training, reinforced through supervisor approval, normalized until it felt like procedure, even though it violated every procedure that mattered. Garrett had conducted dozens of these stops. Pruitt had supervised many of them. The pattern wasn't isolated, it was institutional. Detective Tate's investigation expanded in parallel. What began as a single complaint became an audit of 4 years of traffic stop data. The numbers told a story the department had never wanted told. Black drivers stopped at rates far exceeding their proportion of roadway traffic. Searches conducted without consent or probable cause. Arrests made on charges that were later dropped or declined for prosecution. The data became part of the DOJ's pattern or practice investigation, became evidence not just of individual misconduct, but of systemic failure, became the foundation for what federal attorneys called the consent decree discussion, the negotiation that would determine whether the department submitted to federal oversight or fought a battle it would almost certainly lose. Meredith watched these developments from the distance her position required. She could not be involved in prosecution decisions, could not consult with investigators, could not use her judicial authority to influence outcomes in a case where she was a victim rather than an arbiter. But she could observe, could read the public filings, could track the progress through legal news services and the informal courthouse network that kept all judges informed of significant developments. And she could prepare for the moment when her testimony would be required again. Not before a grand jury this time, before a trial jury, in open court, with Garrett sitting at the defense table and his attorneys ready to challenge every word she said. That moment arrived on a Tuesday in April. The dogwoods were blooming. The courthouse steps were crowded with reporters and cameras, and the particular energy of a trial that had become a symbol of something larger than itself. She entered through the side entrance. Civilian clothes again. She was a witness today, not a judge. The robes waited in her chambers for tomorrow, when she would return to her own courtroom and her own cases, and the work that continued regardless of what happened in the courtroom 3 floors below. The witness waiting room was small and deliberately isolated. No contact with other witnesses. No opportunity for coordination or contamination of testimony. She sat alone with her thoughts and her memories, and the 4 minutes and 17 seconds that had changed everything. The bailiff came for her at 10:43 a.m. The walk to the courtroom felt longer than it should have. Corridors she had traversed thousands of times seemed unfamiliar, transformed by the knowledge that she was walking toward a witness stand rather than a bench, toward questions rather than answers, toward the vulnerability of being examined rather than the authority of examining. The courtroom doors opened. She entered. The gallery was packed, every seat filled, reporters in the back rows, notebooks ready, law students who had skipped class for a front row seat to legal history, members of the public who had waited in line since dawn for the limited spectator passes. And at the defense table, Officer Wade Garrett. He looked different than he had 6 months ago, thinner, grayer at the temples, the particular erosion that came from months of uncertainty, of waiting, of knowing that your life was being decided by forces you couldn't control. Their eyes met briefly as she walked to the witness stand. She didn't look away. Neither did he. But whatever defiance had animated him that night on the highway had been replaced by something else. Fear, perhaps, or resignation. The recognition that the assumptions he had carried for 12 years about who had power and who didn't, about whose truth mattered and whose could be dismissed, had been catastrophically wrong. She was sworn in, took her seat, faced the prosecutor who would guide her through testimony she had given before in different rooms, to different audiences, but always with the same precision and the same commitment to truth. AUSA Marsh approached the witness stand. Please state your name and occupation for the record. Meredith Holloway. I serve as a United States District Court judge for the Northern District of Georgia. The words hung in the courtroom air. The jury, 12 citizens and 4 alternates, selected through weeks of careful voir dire, absorbed them. A federal judge, on the witness stand, testifying about her own victimization. Judge Holloway, I'd like to direct your attention to the evening of June 14th of last year. Can you describe what happened? She could. She did. The same story she had told before, but with the added weight of a trial setting. The driving, the lights in her mirror, the stop, the compliance, the escalation, the kneeling. She described it in the flat, factual tone she used for judicial findings, times and locations and exact words spoken. No emotion in her voice, though emotion lived in every syllable for anyone listening closely enough to hear it. The jury listened, some took notes. Others simply watched her face, searching for the humanity beneath the judicial composure. She gave them what she could. The truth, unadorned. The experience, unembellished. The 4 minutes and 17 seconds that had felt like hours, that had burned through her slacks and into her memory, that would stay with her for the rest of her life, regardless of what verdict this jury returned. Marsh played the collar mic audio. The courtroom heard Garrett's voice, the dismissal, the assumptions, the people like you that said everything about what this stop had really been about. Then he played the civilian dashcam footage. 4 minutes and 17 seconds of silent video. A woman on her knees. Officers standing over her. The American flag decal visible on one cruiser's bumper, flapping slightly in the wind created by passing traffic. The jury watched. Some shifted in their seats. One woman in the front row pressed her hand to her mouth. When the footage ended, Marsh returned to his questioning. Judge Holloway, in your experience as a prosecutor and a judge, have you ever seen a traffic stop conducted in this manner when dispatch has confirmed valid registration? Objection. The defense attorney rose. Calls for speculation. Overruled. Judge Raymond Ashworth, the colleague who had assumed the Garrett case after her recusal, made the ruling without hesitation. The witness may answer based on her professional experience. No, she said. In my experience, confirmation of valid registration ends the investigative basis for the stop. What followed that confirmation was not consistent with any training or protocol I'm aware of. What was it consistent with? She paused, chose her words with care. It was consistent with a stop based on factors other than legal justification. The officer had decided I was guilty of something before he approached my vehicle. Dispatch confirmation didn't change that decision. It couldn't, because the decision wasn't based on evidence. It was based on assumption. What kind of assumption? Objection. Speculation. Overruled. The witness may describe her perception of the events. She looked at the jury. 12 faces. Diverse, attentive, waiting. Officer Garrett told me that people like you always think they can drive cars like this. He said he knew exactly what he was looking at. The assumption was clear. A black woman driving a vehicle he believed she shouldn't be driving. That assumption persisted despite documentation, despite dispatch confirmation, despite everything I said and did to demonstrate that no crime had been committed. The words settled over the courtroom. The silence that followed was the silence of truth acknowledged, of reality confronted, of a pattern exposed that many had experienced but few had been able to prove. Cross-examination followed. The defense attorney approached with the particular energy of someone whose case depended on discrediting a witness who couldn't be easily discredited. Judge Holloway, you've testified that you announced each movement before making it during the stop. Is that correct? Yes. And you did this because you were afraid of how the officer might react? I did this because I was trained to do it. Because every black person in America is trained to do it. Because compliance is survival when you're dealing with law enforcement that has already decided you're guilty. So you're saying you expected to be treated unfairly before the stop even began? I'm saying I prepared for the possibility, as I have prepared for that possibility every time I've been stopped in 48 years of driving. The attorney shifted tactics, tried to suggest that her recollection was colored by her legal training, that she had reconstructed events to fit a narrative, that her precision was evidence of fabrication rather than accuracy. She answered each question with the same calm she brought to her courtroom. Let the attacks land without flinching, trusted that truth was its own defense. The cross-examination lasted 2 hours. When it ended, she stepped down from the witness stand and walked out of the courtroom without looking at Garrett again. There was nothing more to see, nothing more to say. She had given her testimony. The rest was up to the jury. The verdict came 3 days later. Guilty on both counts. She received the news in her chambers, delivered by Julian, whose face carried an expression she had rarely seen. Something like joy, tempered by the awareness that joy felt inappropriate given everything that had led to this moment. Sentencing in 6 weeks, he added. Prosecution is recommending the maximum, 10 years. 10 years. The full weight of federal law applied to the man who had forced her to kneel on burning asphalt because he didn't like what he was looking at. She thanked Julian, returned to the brief she had been reading, continued her work. The victory, if it was a victory, didn't feel like celebration. It felt like arithmetic. 1 officer convicted, 1 officer pleaded, 1 lieutenant transferred but unpunished, a department facing federal investigation but not yet reformed, a system that had produced Garrett and Pruitt and Devlin and countless others still grinding forward, still processing citizens, still making assumptions that the law was supposed to prevent but somehow never did. Partial justice, better than no justice, but so far from enough. Sentencing day arrived 6 weeks later. Meredith submitted a victim impact statement but did not attend the hearing. Her presence would have become the story, would have overshadowed the moment when Garrett learned what his assumptions would cost him. The judge, Ashworth, steady and thorough, imposed 8 years. Not the maximum, but substantial. More than most officers received for civil rights violations. More than the system usually demanded from its own. Garrett was taken into custody immediately. The images made national news. An officer in handcuffs, led from a federal courtroom, beginning a sentence that would consume most of a decade. The defense announced an appeal. Of course they did. The process would continue for years, through circuit courts and possibly beyond. Nothing was ever truly final in the legal system. But for now, for this moment, there was consequence. 1 domino fallen. Others remained standing. The consent decree negotiations began the month after Garrett's sentencing. City attorneys and federal attorneys in conference rooms, arguing over language, debating requirements, fighting about the scope of oversight that would reshape the department for years to come. Meredith followed the progress through public filings and legal news. The city initially resisted. Consent decrees were expensive, intrusive, embarrassing. They proposed alternatives, voluntary reforms, internal oversight, promises of change that wouldn't require federal supervision. The DOJ rejected each alternative. The pattern or practice investigation had documented too much. Training failures, supervision failures, a complaint system designed to discourage complaints. Data that revealed racial disparities the department had never examined because examining them would have required acknowledging them. The negotiations continued through summer, through fall, into the holiday season when attention was elsewhere and deals could be struck without excessive scrutiny. The final consent decree was announced in January. 18 months after Meredith's knees had touched asphalt on the shoulder of Interstate 285. The terms were extensive: mandatory body cam activation, with discipline for failures. Enhanced supervision of traffic stops. Revised training on bias and constitutional requirements. An independent monitor appointed for 3 years with authority to audit compliance and recommend additional reforms. The chief of police held a press conference, acknowledged mistakes, promised transformation, used the language of accountability while carefully avoiding any admission that would expose the city to additional liability. Councilwoman Brenda Oakes was notably absent. Her seat on the Public Safety Committee had been quietly reassigned. Her political future, once promising, had dimmed considerably since the night she dismissed Meredith's arrest as an isolated incident that didn't indicate a pattern. The pattern had been proven. The incident had been anything but isolated, and the people who had tried to minimize both were paying prices of their own, smaller than Garrett's, but real nonetheless. Lieutenant Devlin faced an administrative hearing 2 months after the consent decree. Internal Affairs had documented his role in coordinating statements, in creating the culture of protection that had enabled Garrett's behavior for years. The hearing was closed to the public. The outcome was announced without ceremony. Termination, effective immediately. Pension reduced, but not eliminated. No criminal charges, no public accountability beyond a brief mention in department communications. He disappeared into civilian life. Found work, presumably, in the private sector that absorbed former law enforcement officers regardless of the circumstances of their departure. Escaped the consequences that Garrett and Pruitt had faced, protected by the technicalities that protected so many. Partial justice. The phrase had become a constant companion, a reminder that the system delivered what it was designed to deliver, not fairness, not equity, but outcomes shaped by power and procedure and the particular gravity of institutional self-protection. But partial was still something. Partial meant Garrett in prison, Pruitt on probation, Devlin unemployed, a department under federal oversight. Policies changed, at least on paper. Training revised, at least in curriculum. The possibility, not the guarantee, but the possibility, that the next officer considering a profile stop might hesitate. That was the arithmetic of change. Not transformation, but accumulation. Not revolution, but erosion. The slow wearing away of systems that resisted wearing, stone by stone, case by case, receipt by receipt. Meredith returned to her routine. The cases, the briefs, the decisions that shaped lives in ways smaller than her own case, but no less significant to the people involved. Spring arrived again, a year since the trial, 18 months since the night that had changed everything. She was reviewing a civil rights complaint, a different officer, a different department, a different plaintiff, when Julian knocked twice and entered. "Something came for you. No return address." He placed an envelope on her desk. Plain white. Her name, handwritten. No postmark, hand-delivered, apparently, through the courthouse mail system. She opened it carefully. Inside, a single sheet of paper, typed, unsigned. The words were brief. "You got 2 of them. There are more. The files are in Evidence Locker 7C. Case numbers below. When you're ready." Below the message, a list of 6 case numbers. Cold cases, she assumed. Complaints that had been filed and buried. Patterns that had never been connected. Evidence that someone inside the department had preserved, waiting for the right moment to surface. A friend. The letter was signed with only those 2 words. No name, no identification, just the offer of information and the implicit promise of more. She read the letter twice, folded it, placed it in her desk drawer, locked the drawer. When you're ready. Not if, when. The assumption that she would continue, that this case was not an ending, but a beginning, that the receipts would keep accumulating and she would be there to use them. The assumption was correct. She picked up her phone, dialed Detective Tate. "I received something, anonymous, possibly related to ongoing pattern investigations. I think you should see it." Tate arrived within the hour, read the letter, made copies, began the process of pulling the case numbers, of examining whatever evidence Locker 7C contained, of following threads that might lead nowhere or might lead everywhere. The investigation continued, because investigations always continued. Because the system produced violations faster than accountability could address them, and the only response was to keep addressing them anyway, one case at a time, one receipt at a time, one partial victory at a time. 3 months later, another development. The anonymous source had provided accurate information. Evidence Locker 7C contained files related to 6 complaints over 8 years. Different officers. Similar patterns. Equipment malfunctions and coordinated statements and supervisors who signed off without verification. 2 of the officers were still active. Detective Tate opened new investigations. AUSA Marsh reviewed the evidence for potential federal charges. The system was being forced to examine itself. Not because it wanted to, it never wanted to, but because the receipts had accumulated past the point of denial. Because a federal judge had been put on her knees and refused to accept it. Because one night on the shoulder of Interstate 285 had become a catalyst for scrutiny that should have happened years ago. The trials would take time. The appeals would take longer. The institutional change would be measured in decades rather than months. But the direction was set. The clock that had started ticking 18 months ago was still running. Would keep running. Would mark time through whatever came next, through victories and setbacks, through progress and resistance, through the endless work of making systems accountable to the people they claimed to serve. Meredith understood this, had always understood it, had built her career on the understanding that justice was not an event but a process, not a destination but a direction, not something you achieved but something you pursued. She would keep pursuing it, because that was what judges did, what prosecutors did, what anyone committed to the rule of law did when the law was being violated by those sworn to uphold it. She picked up the next file on her desk. Another case. Another set of facts requiring analysis. Another opportunity to apply law to circumstance and see what emerged. The work continued. It always continued. And she was there to do it. Summer turned to fall. The anniversary of Garrett's conviction passed without ceremony. The consent decree monitor filed quarterly reports documenting slow, uneven progress. Some reforms implemented, others delayed, the department resisting where it could and complying where it had to. Pruitt completed her probation, disappeared from public view, presumably rebuilt her life in some quiet corner where her past wouldn't follow too closely. Garrett's appeal was denied. His attorneys filed for Supreme Court review. The odds of acceptance were minimal. The court took fewer than 100 cases per year, and civil rights convictions rarely made the cut. He would serve his time. 8 years, minus whatever good behavior credits the federal system allowed. He would emerge in his 50s, no longer an officer, no longer protected by the institution that had enabled him. Just a man with a record, trying to find his place in a world that had moved on without him. Meredith thought about him occasionally, not with satisfaction or vengeance. Those emotions had burned out long ago, replaced by something more like exhaustion. The exhaustion of someone who had fought a battle she never asked for and won a victory that changed less than it should have. But she didn't dwell on him. Dwelling accomplished nothing. There were too many cases to review, too many decisions to write, too many opportunities to make the system marginally better through the work she had been doing for 15 years. The anonymous letters continued to arrive. Not frequently, perhaps once every 2 months. Each one containing new information, new case numbers, new threads to pull. Someone inside the department was still feeding intelligence to those who could use it, still taking risks to expose what the institution wanted hidden. She never learned who the friend was, never tried to find out. The anonymity protected them both, protected the source from retaliation, protected her from accusations of improper coordination. The information flowed through proper channels, to Detective Tate, to the DOJ, to the investigators who could act on it without compromising their cases. The system was changing, slowly, incompletely, but changing. 2 more officers were indicted. 1 pleaded guilty. 1 went to trial and was convicted. The pattern or practice investigation expanded to include a second precinct. The Federal Monitor's reports grew more detailed, documenting both progress and persistent problems. Councilwoman Oakes lost her re-election bid. Her opponent ran on a platform of police accountability and won by 7 points. The new council member joined the Public Safety Committee with a mandate for reform and the political capital to pursue it. These were not transformations. They were increments, small shifts in a vast system that resisted shifting. But increments accumulated, became trends, became, eventually, the foundation for something more substantial. Meredith watched it happen, participated where she could, maintained the boundaries her position required. A judge couldn't be an activist, couldn't advocate publicly, couldn't push the system in directions it wasn't ready to go. But a judge could rule fairly, could apply the law without favor, could ensure that the cases reaching her courtroom were decided on merits rather than assumptions. That was her contribution. The contribution she had been making for 15 years and would continue making for however many years remained. It was enough. It had to be enough. Because expecting more was a recipe for disappointment, and she had experienced enough disappointment to last several lifetimes. 2 years after the night that changed everything, she sat in her chambers reviewing a motion. Outside her window, Atlanta hummed with its usual energy, traffic and construction, and the millions of small dramas that constituted urban life. Julian knocked twice, entered. The Robinson case, the excessive force complaint you were assigned last month. Defense filed a motion to dismiss. She accepted the file, opened it, read the motion. Different officer, different precinct. Same arguments she had seen 100 times. Qualified immunity. Lack of clearly established right. The procedural shields that protected officers from accountability even when their conduct was clearly wrong. She read the case file again. The plaintiff's allegations, the officer's response, the evidence that had been gathered in the months since the incident. The pattern was familiar. Late-night stop, alleged vehicle matching a profile, escalation without justification, force applied to a compliant suspect, equipment malfunction on the body cam. She set down the file, looked out her window. The system had not changed, not fundamentally, not in the ways that would prevent the next Garrett from making the same assumptions and taking the same actions. The reforms were real, but limited. The oversight was active, but temporary. The consent decree would expire eventually, and what happened after that was anyone's guess. But she was still here, still on the bench, still reviewing cases and writing opinions and making decisions that shaped lives. Still fighting. The motion to dismiss would be denied. The evidence was sufficient to proceed. The officer would face trial, and a jury would decide, and whatever outcome emerged would become part of the record. One more case. One more opportunity. One more increment in the endless accumulation of accountability. She picked up her pen, began drafting her ruling. The work continued. It always continued. That evening, she drove home. The same route she had driven for years. The same Camry, gray and unremarkable, invisible in the way she had learned to value. At the intersection near her house, a cruiser pulled up beside her at the red light. The officer looked over. Young, white, new to the job, probably. His posture had the particular stiffness of someone still adjusting to the uniform. Their eyes met. He held her gaze for 3 seconds. 4. 5. Something flickered across his face. Recognition, perhaps, or uncertainty. The calculation of someone trying to decide if the woman in the next car was the woman he had seen on the news. The woman whose case had changed everything. The woman who had proven that assumptions had consequences. The light turned green. He drove away first. No stop, no siren, no flashing lights. Just a look. A moment. A reminder that the battle never ended, that the system never stopped testing, that vigilance was not a choice, but a requirement. She drove home, parked in her garage, sat in the car for a long moment before going inside. The anonymous letter waited in her desk at the courthouse. The missing 10 minutes of collar mic audio, still unexplained, still under forensic analysis, waited in an evidence server somewhere. The next case waited on her docket. The system waited, resistant and resilient, ready to protect itself from accountability whenever accountability grew complacent. Justice was never finished. It was only, ever, a holding action. And tomorrow, she would hold the line again. The house was quiet when she entered. Ethan in his office, finishing the workday, the evening stretching ahead, ordinary and precious in its ordinariness. She changed clothes, started dinner. Let the routine carry her into the rhythm of domestic life that had sustained her through everything: the arrest, the trial, the year of scrutiny, the endless aftermath. Ethan appeared in the kitchen doorway, watched her for a moment before speaking. "You looked at the Robinson case today." It wasn't a question. 19 years of marriage had taught him to read her silences. "I denied the motion to dismiss. It goes to trial." Same pattern? Same pattern. Different faces, different names, same assumptions. He crossed the kitchen, stood beside her at the counter, let his presence communicate what words couldn't. "You're not going to fix it," he said finally. Not accusation, just observation, the acknowledgement of a truth they both knew. "No." She set down the knife she had been using, met his eyes. "But I'm not going to stop trying." He nodded. The nod of someone who had accepted this truth years ago, who had married a woman committed to impossible work, who had built a life around supporting that commitment even when the costs were high. "Dinner in 20 minutes, she said. "I'll set the table." He left. She returned to cooking. The simple mechanics of feeding a family, of maintaining a home, of existing in the spaces between battles. Outside, the city darkened. Streetlights flickered on. Traffic thinned as evening settled over Atlanta. Somewhere a young officer was beginning a shift, would make decisions tonight that affected lives, would carry assumptions, conscious or not, that shaped those decisions, would be watched by dash cams and body cams and the 1,000 eyes that modern policing had accumulated, would be held accountable, maybe, if those assumptions led to harm, would face consequences, possibly, if the system decided consequences were warranted, or wouldn't. That was the uncertainty, the perpetual unknown, the question that could never be fully answered because the system kept changing and kept staying the same, kept producing violations and kept producing accountability, kept failing and kept trying. Meredith understood this, had made peace with it, or something close to peace. The understanding that her work was not about winning, but about continuing, not about transformation, but about resistance, not about achieving justice, but about pursuing it, day after day, case after case, until the pursuit itself became the point. Tomorrow, she would return to Chambers, would review the briefs waiting on her desk, would write opinions and make rulings and do the work that federal judges did, would hold the line, because someone had to. Because the alternative, giving up, accepting defeat, letting the system operate without challenge, was not something she could live with. Because her father had taught her that you changed institutions by mastering them, not abandoning them. Because a night on her knees on burning asphalt had proven that no one was exempt from the system's failures, and therefore no one was exempt from the responsibility to fix them. Dinner was ready at 7. She and Ethan ate at the kitchen table, talking about small things, avoiding the large things that would wait for another day. Afterward, she sat in the living room with a book she didn't read, thoughts drifting to the morning, to the cases, to the Robinson file that would proceed toward trial and produce whatever outcome it produced. Her phone buzzed, a text from an unknown number. She opened it. The files in 7C led somewhere. 3 more officers. Federal grand jury next month. Thought you should know. A friend. 3 more. The dominoes continuing to fall. The pattern being exposed, one case at a time. She typed back, "Thank you. Stay safe." No response. None expected. She set down the phone, looked at the window, at the darkness beyond, at the city that contained multitudes, officers and civilians, power and powerlessness, justice and its absence. The investigation continued. The work continued. The clock that started on the shoulder of Interstate 285 continued ticking, measuring time toward outcomes that couldn't be predicted and conclusions that might never arrive. But ticking was what mattered. Movement. Progress. The refusal to accept that things couldn't change because things had always been this way. They could change. They would change. Slowly. Painfully. Incompletely. But change would come, because receipts accumulated, because patterns emerged, because sometimes, not always but sometimes, the right person ended up on their knees at the wrong time and refused to accept that the wrong time meant the wrong outcome. Meredith Holloway closed her eyes. Tomorrow she would fight again. Tonight she would rest. The battle was far from over, but she was still standing, and that, in the end, was what mattered most. The house settled into silence around her. Ethan's footsteps upstairs, moving toward bed. The refrigerator's hum, the distant sound of traffic on roads she couldn't see. She opened her eyes, looked at the ceiling. Somewhere in a federal prison, Wade Garrett was learning what consequences felt like. Somewhere in the department, an anonymous friend was collecting evidence that would bring more consequences to more officers who thought they were untouchable. Somewhere in the system, change was happening, slow and imperfect, but happening. And here, in this house, in this life she had built through decades of work and struggle and refusal to accept what was unacceptable, she was preparing for another day, another case, another opportunity to make the system answer for itself. The story didn't end here. Stories like this never ended. They just continued, generation after generation, the endless work of making institutions live up to the ideals they claimed to represent. She would continue, too, for as long as she could, for as long as it took, because justice demanded nothing less, and she had never been willing to give justice anything less than everything she had. The morning would come. The alarm would sound at 4:58 a.m., 2 minutes early, as always. She would run her route through Piedmont Park, pace steady, mind clear. She would dress in the armor of professional competence and drive her unremarkable car to the courthouse where her name was written in tarnished brass on a door she had earned the right to open. She would do the work. She would hold the line. She would keep fighting until there was nothing left to fight, or no one left to fight it. And even then, even if that day ever came, the work would continue through others. Through the law students watching from gallery seats, through the young attorneys filing their first civil rights complaints, through the officers who chose conscience over solidarity and fed evidence to investigators who could use it, through everyone who looked at a system designed to resist change and decided to change it anyway. The work was bigger than any one person, but every person mattered. Every case mattered. Every receipt, every testimony, every ruling that held power accountable, they all mattered. They were the bricks in a wall that was being built one piece at a time, a wall against injustice that would never be complete, but was always being built. Meredith Holloway had added her bricks. Tomorrow, she would add more, and the wall would rise a little higher, and justice, imperfect, incomplete, eternally pursued, would be a little closer than it was today. That was the work. That was the calling. That was the only response to a system that put federal judges on their knees on burning asphalt and expected them to accept it. They would not accept it. She would not accept it. Not ever. Not while she had breath and bench and the stubborn refusal to pretend that wrong was right, because right was hard. The night deepened. She went to bed. The alarm was set for 4:58 a.m. Tomorrow waited, and she would be ready.
Thank you for taking the time to watch this video today. If you found the content helpful, please remember to like and subscribe so you won't miss our upcoming episodes. If you have any questions or suggestions, feel free to leave a comment below. We are always here to listen.